Hello everyone, and welcome to Pop de Jure, where pop culture and law collide. I'm your host, attorney Chinwe Foster, and this video has been sponsored by the Foster Law Firm. All images and information in this video are for educational purposes only. So now, let's get into this week's episode. So once you have that final order from a divorce, a legitimation, or a custody proceeding, that final order is supposed to last you and the other parent until your child graduates from high school. However, there are some instances where that order no longer works. In that instance, you would need to file a modification action. I'm attorney Chinwe Foster with the Foster Law Firm, and on this episode of Pop de Jure, we're going to talk about modification actions. Let's get into it. While we see ugly co-parenting situations all the time, it's always in the children's best interest and also in your financial best interest when there's an amicable co-parenting situation. There's some celebrities that have shown that having an amicable co-parenting relationship is better for all parties involved. Russell Simmons and Kimora Lee Simmons managed to establish what publicly appears to be a partnership in how they raised their two daughters. Lisa Bonet and Jason Momoa announced that they were going their separate ways in January 2022. However, they've both said that they have an unwavering devotion to their children, and so far there appears to be no drama between the two when it comes to co-parenting their children. Drew Barrymore and her husband Will Kopelman divorced in 2016, but they still celebrate holidays together with their daughters. The former couple even went trick-or-treating together with their new significant others.
Yes, I went trick-or-treating on Sunday with Will and his beautiful wife, Allie, my daughter's wonderful stepmother.
Drew Barrymore said in a 2020 interview, "None of us want to get it wrong for our kids. What happened in the marriage is not about the parenting. This is about the relationship with their dad and their mom, not about their relationship with your marriage." In an amicable co-parenting relationship, it is much easier and less financially taxing to modify the court's prior order. In order to file a modification action in Georgia, you have to be able to show the court that there's been a material change of circumstance since the prior order that's affecting the children's best interests. You can't just file a modification action because you don't like the court's prior order. You have to be able to show the court that something has happened that's material that warrants the court changing its order. Now, many people have different definitions of what material is. So it's important for you to contact an experienced attorney, like the attorneys here at the Foster Law Firm, to ensure that you have a strong modification case when you file it with the court. Some examples of material changes in circumstances is if you have one party that's moving out of state and them moving substantially affects the parenting time of the other parent. Or you may have a situation when one party is not following the court's order, and them not following that court's order is substantially affecting the best interest of the children. In some instances, one party's income has changed. And I don't mean that you get a slight raise. I mean that the income that you're making now, the income that one party's making now, is substantially different than what they were making when the court first issued the order. Or you may have a child in Georgia who's the age of 14, and they've decided that they no longer want to live with the parent that they're living with, and they actually want to spend more time or live with the other parent. These are some examples of material changes that warrants a modification action. When R&B superstar Usher Raymond divorced his first wife, Tamika Foster Raymond, she initially received custody of the couple's two sons. Usher sought to modify that custody agreement by alleging that Tamika made co-parenting difficult due to her emotional and anger issues which ultimately alienated him from his sons.
Raymond says she took a now sealed psychological examination, which found she had a, quote, moderately severe mental disorder, a diagnosis she's now challenging.
The psych evaluation was something that his side ordered and said that we both had to take it. I had narcissistic personality traits. That's what actually the diagnosis was.
Usher was successful in showing that there was a material change in circumstance that affected the children's best interest, and he was able to modify the court's prior order and received primary custody of his 2 sons. Singer Ciara sought to modify her custody agreement with rapper Future because she argued that Future was not spending enough time with the son that they shared together. In the petition that Ciara filed, she argued that Future had missed over 37% of his scheduled visits with their son. She also argued that during the time that he did have their son, that he would drop him off at their relatives' homes and was not actually spending time with him. The parties were ultimately able to reach an agreement that was signed off on by the judge that modified the rapper's parenting time with his son. Not only can you modify custody, you can also modify child support when there has been a material change in your financial circumstances. For example, former Spice Girl Mel B was able to modify the child support that she receives from Eddie Murphy for their daughter. In filing her action to modify, Mel B claimed that her income had dramatically decreased and that she needed additional assistance from Eddie Murphy. Mel B was able to increase the child support that she receives from $25,000 a month to $35,000 a month. In Georgia, a child that's at least 14 years old can make a decision and make an election and tell the court what parent they want to live with. The court will usually go with the child's election unless it's determined that that child's election is not in that child's best interest. The court determines what's in the child's best interest by looking at several factors as codified in Georgia Statute OCGA 19-9-3. Some examples of these best interests of the child factors are the stability of the parent's knowledge of the child's needs, the parent's ability to provide financially for the child, the mental and physical health of the parent's work schedule, or the ability of that parent to co-parent with the child's other parent. There are other factors, but these are just some of the factors that the court will look at in determining whether a child that's at least 14 years or older, that their election is in their best interest. In some cases, a child that is between the ages of 11 and 14 can make an election as well. However, that child's election is not a material change in circumstance that warrants a modification, but the judge has discretion to consider that child's desires. In these instances, a judge will likely appoint a guardian ad litem to investigate what's in the child's best interest. A guardian ad litem is an attorney that's appointed by the court and typically paid for by both parties. The guardian ad litem investigates both parties and makes a recommendation to the court as to what's in the child's best interest. You want to be very careful before submitting an election to the court. I've seen many times where one parent influences or pressures the child to submit an election. If the court determines that the child was influenced or pressured by one parent, that could detrimentally affect your custody case. Now, can you modify without going back to court? The parents can agree that they want to modify visitation. However, custody and child support can only be modified by the judge. The parenting plan visitation is a fallback provision if the parties cannot agree. However, both parents can decide whatever they want to do about visitation. But when it comes to custody and child support, only a judge can sign off on changing what was previously ordered. So if you and the other parent have come to an agreement that custody should change, you can contact the Foster Law Firm and we can assist you in drafting a consent modification order that can be presented to the court for the judge to sign off on. I've seen one too many times where the parents have reached an agreement that the child is going to go live with the other parent, but they never make it official. So what happens is that the child support for the parent that the child is actually living with is still accumulating. Or all of a sudden the other parent gets mad and just decides to go back on the agreement and just comes and snatches the child back, and there's nothing that you can do about it. So if you are in agreement with the other party, make sure that you file a consent modification order with the court so that it is official. Same thing with child support. The parents can't just decide that the non-custodial parent is not going to pay child support. In Georgia, child support is not for the parents, it's for the child, so it can't be waived. However, there are ways to modify or zero out child support with deviations. So make sure that you consult with an experienced attorney, like the attorneys here at the Foster Law Firm, to assist you in modifying your child support order. What is the difference between contempt and modification? In some instances, there may not be a material change that warrants a modification, but it may be enough to file a contempt action. If one party is not following the court's prior order by not allowing visitation, by not paying child support, or by not following any other provision of the court order, the other party can file a contempt action and ask the court to punish the other party for not following the court's prior order. In certain instances, one party's contemptuous behavior may be grounds to file a modification action. However, if it's not a material change in circumstance, you can still file a contempt action and ask the court to punish the other party for not following the court order. Click like and subscribe to be up to date on all of our episodes. You can also follow us on all social media platforms at FosterLawGA. If you have any questions about today's episode or any questions in general, submit your questions to info@FosterLawGA.com.